Hello, everybody. This is Jennifer Schaus coming to you live from Washington, D.C., and we are continuing in our Webinar Wednesday series. So thanks for joining us. Today we are joined by Brian King, who's going to be talking about bid protest, but just a general overview about our webinars. Our presenters range from attorneys to accountants and other industry experts. We do host a webinar every Wednesday at 12 o'clock and 12:30. Two different topics. They are all complimentary. They are all recorded. You can find the recordings on our website under the webinar section. We have an archived tab. If you click on that, that has all of the previous webinars from this year as well as previous years. And you can also follow us on YouTube to stay abreast of upcoming webinars and all of the recordings as well. These are all, as I mentioned, recorded. If you do have questions, in the interest of time, we just ask that you send your questions directly to the speaker, and Brian's contact information will be found on the last slide. So you can contact him directly for any questions about bid protests today. A little bit about us. We are based in downtown DC and provide professional services for government contractors. We serve both domestic and foreign companies, product and service firms, mid-size and large businesses. And some of our services are listed there, which range from proposal writing, contract vehicles, including the GSA schedule, market analysis reports, contract administration, compliance, and more. We do host networking events and seminars throughout the year. You can find those on our website under the events section. This slide here that you see has some GSA schedule classes that we are delivering, as well as construction conferences that are coming up in the coming months. These are all listed on our website under the events section. So we're lucky enough to be joined by Brian King today. His background is listed here on this slide. And again, today he is talking about Bid Protest 101. So without further ado, I'm going to give the floor over to Brian. And thanks again for joining us, Brian, and I'll let you kick this off.
Okay, thank you, Jennifer. As Jennifer mentioned, my name is Brian King. I am a partner at Offutt Kerman, located here in our Tysons Corner, Virginia office, and my practice is focused on federal procurement. Basically, I assist government contractors with whatever issue that may arise as they're pursuing government contracts. And one of the things that comes up quite often is the issue of bid protests. And I get the question a lot, like, what is a bid protest? So that's what we're going to talk about today. We're just going to go over the basics of the bid protest process. What is it? Where are they filed? Who can file? What are the deadlines? And those sorts of questions. So let's just get right into it. What is a bid protest? So generally, a bid protest is a way for contractors to serve as sort of watchdogs of the procurement system. It's a way, it's a statutorily created right which allows them to challenge terms of solicitations, allows challenges to evaluations, award decisions, to ensure that the procurement is conducted in a fair and objective way. And it's important that contractors know the rules for bid protests and know what their rights are. Otherwise, they could lose out on an opportunity to protest, and oftentimes that means losing out on an opportunity for an award. Next slide, please. So who can file a bid protest? So basically, a protest can be filed by any interested party, and the regulations define an interested party basically as anyone with a direct economic interest. And so most of the time that is an actual bidder on a contract, or in some cases it can be a prospective bidder on a contract. But they need to have a direct economic interest that would be affected by the award of a contract or by the agency's failure to award the contract. Typically, this means somebody that's interested in bidding on a solicitation but may not like the way that the terms of the solicitation or the evaluation criteria that's been established are listed in the solicitation, and they want those terms to change. Or it's a disappointed offeror that submitted an offer on a procurement and did not win but felt that they should have won. So next slide, please. So where are these bid protests filed? As you can see, there are three primary forms for filing bid protests. There are some other forms out there, such as the FAA, ODRA, which is specific for FAA procurements. But for the most part, we are living in a world with just three options for where you're going to file your protest. You can file at the agency level, which is filed directly with the contracting officer. There are protests at the GAO, which is an administrative body that primarily just hears these. The Inspector General hears these protests. There are administrative attorneys. They're not judges, they're attorneys that hear these protests, but they get thousands of these every year, so they're very familiar with the procurement system and the protest process. And then there is the U.S. Court of Federal Claims, which is a court that was created by Congress specifically to hear claims against the federal government. Okay, next slide. Okay, so let's talk a little bit about what the main types of protests are. There are some that don't quite fit neatly into either of these categories, but for the most part, we're dealing with two types of protests. There are pre-award protests, which are challenges to the terms of the solicitation or with the ground rules of the procurement. And then there are post-award protests, which challenge the agency's evaluation and award decision. And the type of protest that we're talking about sort of dictates everything else regarding the protest, as far as like the timeliness, what are the types of arguments that you're going to need to file, and sometimes even what forum you may want to look towards. Next slide, please. Okay, so deadlines. This is very important. Like as I said earlier, it's very important that contractors know their rights and know what the deadlines are, because if you fail to file a protest on time, they are very rarely not dismissed. Agencies and GAO will dismiss a protest as untimely as quickly as they possibly can. So agency level protests and GAO protest, if it's a pre-award protest, it needs to be filed before the due date for the receipt of proposals or bids. One of the common mistakes that a lot of protesters make is that they will wait to see how procurement's going to shake out before they decide to protest. Let's see if we win this thing, and if we don't, then we'll challenge the terms of the solicitation as unfair. Well, that's not going to fly because any protest that has any challenge to the terms of a solicitation has to be filed before the due date for proposals. Otherwise, it's going to be dismissed as untimely. So if you have one of those types of protests, please do not wait. As for post-award protests, at the agency level, they need to be filed within 10 days of when the protester knew or should have known of the grounds of the protest. At the GAO, it's very similar, also within 10 days of when the protester knew or should have known of the grounds of the protest. Or if it's a procurement with a required debriefing, then the protester can wait 5 days after the debriefing to file their protest, whichever is later. And most of the time, if there's a required debriefing, the debriefing is going to be held around that 10-day point. So usually in that case, the debriefing, the 5 days after the debriefing, will be the later of the two. And then there's the Court of Federal Claims, which does not have any set time limit for protests, just needs to be in a reasonable time. But the court has basically followed the same timeline that agency and GAO follows for pre-award protests. They need to be filed before the due date for receipt of proposals. Post-award, it just needs to be, it can't be a serious delay in filing the protest. Next slide, please. So after a bid protest is filed, in some cases, there's what's called a seek a stay of performance. The Competition and Contracting Act requires that in certain circumstances, agencies basically put a hold on everything that they're doing while the protest is being resolved. Now, this is available either for agency level or the GAO protest. If it's before an award is made, then the agency cannot make an award without substantial justification. And if it's a protest after award, then the agency is required to suspend performance as long as the protest was filed within the applicable time frame. So It's a little different for the CICA stay. If you remember, for post-award protests at agencies and GAO, it's within 10 days of when the protester knew or should have known, or within 5 days of the required debriefing. For the CICA stay, it's a little different. It has to be filed either within 10 days of contract award or within 5 days after required debriefing, whichever is later. So, this gets a lot of protesters into trouble as far as timing if it's a protest where there was no required debriefing, because they will stick to the 10 days within 10 days of when they knew or should have known of their protest, which allows them to file the protest at GAO and be timely. But if that same 10 days is not within 10 days of the award of the contract, because sometimes you find out about what your grounds are after the award's made, then you may not get the CICA stay. So it's important to be aware of these competing timelines and make sure that you preserve all your rights possible. Now, agencies can override a CICA stay in certain situations, but it's also possible for protesters to challenge the override of a stay. Those challenges are held at the Court of Federal Claims. Next slide, please. Okay, so what happens if your award is protested? Generally, you always want to intervene. So at the agency level, they do have discretion to allow interveners, but it's very rare that they would do so. At the Court of Federal Claims and at GAO, awardees are allowed to intervene as a matter of right. And basically what this means is it provides awardees with an opportunity to kind of keep an eye on what's going on with the protest and possibly defend their own award. Because a lot of times protests will be specifically about how the agency treated the protester and may not involve the awardee's proposal. But a lot of times protesters will actually attack an awardee's proposal and their ratings and say that they should not have received the ratings that they did, or that their pricing demonstrated a lack of understanding, or whatever the case may be. And so in those situations, it's very helpful as an awardee to have the option to review those arguments and respond to those arguments, because interveners can file comments on agency report and other filings just as the protesters are. So as I said, it's always recommended that you intervene if your award has been protested. So next slide, please. Okay, so let's talk a little bit about the different protest forums. First, we'll go through agency level protests. Now, these are filed directly with the contracting officer, but agencies are required to have an option for an independent review above the contracting officer. But those depend, they vary agency by agency. But for the most part, agency level protests are going to be submitting a protest letter. It's very informal. A lot of times it can even be sent just as an email. As long as you include what the grounds of the protest are, there's no real process for it. You send your complaint to the agency, to the contracting officer, and then you wait for a decision. Agencies are required to issue a well-reasoned decision within 35 days when practicable. I can say anecdotally, for the most part, agencies hit that deadline, if not exceed it. File their response shorter than the 35 days, because as I mentioned earlier, if you file an agency level protest, you do get the CICA stay. And so for the most part, agencies are kind of in a hurry to get the protest process resolved so that they can move forward with the procurement. Now, the types of relief, they can correct the solicitation deficiency, they can void a contract, they can reevaluate proposals. But I can tell you that for the most part, agency level protests are very rarely successful. because you are essentially just asking the contracting officer to change their mind, and that usually doesn't happen. Next slide, please. So now we're talking about GAO protests, which are by far the most common forum for filing bid protests. All GAO protests now must be filed using their new electronic filing system. This was introduced earlier this year. Previously, everything was pretty much handled in a GAO protest via email, but now there is an electronic filing system in place, and there's a $350 filing fee for protests, and they say that the fee is basically for the maintenance and implementation of the filing system. Thankfully, there's no extra fee for additional filings, including any supplemental protests. But, you know, that's something new that protesters need to consider in deciding whether or not they want to file a protest at GAO. So, as I said, in order to file a protest, you have to be an actual prospective bidder with a direct economic interest in the award. For sealed bids, this usually means you're next in line for award, or if you're not next in line for award, your protest is challenging everybody ranked ahead of you. Because if you're fourth in a sealed bid and you're only challenging the first place bidder, well, even if you win, you're still not going to receive the award because there are two other companies ahead of you. So you need to be either next in line or challenge everybody on top of you. For negotiated, it just means that you need to have a reasonable chance of receiving the award if your protest is successful. And because most negotiated procurements are handled with a best value determination, it's usually pretty easy to argue that if your proposal was evaluated differently, or if the agency actually adhered to the requirements of the solicitation as far as how they were going to evaluate proposals, that there was a reasonable possibility that your proposal could have been selected as the best value. So GAO will actually give a great deal of deference to the discretion of the agency. The GAO, the way they look at it is that the agency knows best what they need and you know, how their procurement should be run. And so unless it is an unreasonable determination or decision or practice or procedure used by the agency, GAO is probably going to just defer to their discretion. And for protests that involve proprietary confidential information, GAO will issue a protective order. Now, the way that works is that only people that are admitted under the protective order are allowed to see the protected and confidential material. So for contractors, usually this means that they need to engage outside counsel so that the outside counsel can then be admitted under the protective order. And it gets to be a little tricky sometimes in discussing the merits of the protest or the various issues going on in the protest with your client, with the actual protester. Because under the protective order, you're not allowed to reveal the sensitive information. However, there are ways to discuss generally what's going on in the protest, just to make sure that the protester is apprised of what's happening, even if they're not privy to the sensitive and confidential proprietary data. And finally, they do have hearings at GAO, but they are very, very rare. I believe I saw only maybe 3% of cases go to hearing, but something very, very low. Next slide, please. So the process for for a GAO protest is the protest is filed, and then 30 days later, the agency is required to file what's called an agency report. An agency report contains all of the documents in the agency's possession that is relevant to the protest grounds. Now, it's important to note that generally speaking, GAO is not going to require an agency to include any documents in the agency report that does not directly relate to one of the protest grounds filed by the agency, filed by the protester. So this becomes an issue a lot of times if the protester is mad at the way the agency evaluated its own proposal, and so then it files its protest arguing that the agency should have evaluated its proposal differently, and then the agency report comes out and everything is about the protester's proposal and there's no information about how the agency evaluated the awardee's proposal. Well, this will be a fight most of the time, but GAO will invariably rule that because the protest did not bring into issue the awardee's proposal, that the agency report does not need to include documents related to the awardee's proposal. So that's something to keep in mind for protesters. If they do want to see those sorts of documents in an agency report, then they need to make sure that they include arguments in the protest attacking the awardees or whatever the case, the situation is. After the agency report is filed, the awardees and any interveners then have 10 days in which to file comments on the agency report. This is also a time where protesters often will file supplemental protest grounds. So, you'll learn about something in the agency report, and, this will be new information that you didn't know when you filed your original protest, and, these are separate and independent protest grounds. And so the same rules apply for supplemental protests as for post-award protests. They need to be filed within 10 days of when the awardee knew or should have known. So if it's something that was learned during the review of the agency report, then you have 10 days from when the agency report was released to file any supplemental protest grounds. If any grounds that were discussed in the agency report are not addressed in comments, then GAO will deem those grounds as withdrawn. So it's important that protesters file comments, because if they don't file comments, their protest will be withdrawn. But when they file comments, that they actually address everything that was addressed in the agency report. And GAO protests have a pretty fast timeline. They are required by regulation to be resolved within 100 days. And there's also an express option for a 65-day protest period, which is not really, protesters don't usually request that option. The 100 days is usually is pretty standard. Next slide, please. So as I said, protests may be withdrawn, and they can be withdrawn by a protester at any time. Agencies may also take corrective action at any time. So what happens a lot of times with protests is a protester will make arguments about mistakes that the agency made, and then the agency will say, yeah, you know what, you're right. We did make those mistakes. We didn't think about it that way. We are going to voluntarily take corrective action in response to this protest and go back and fix the issue. And then when that happens, for the most part, GAO will dismiss the protest as academic, because they want to see what the agency does in their corrective action. If a protest goes all the way to decision, GAO can issue a decision that either denies the protest, or it could dismiss certain protest grounds, or GAO can sustain. They can sustain either all of the protest or specific protest grounds, and then GAO issues a recommendation to an agency. Because GAO is an administrative body, they do not issue decisions like a court would. They issue recommendations. But for the most part, agencies will always follow GAO's recommendations, because at the end of the year, GAO issues a report to Congress, and then they are required to identify any agencies that failed to follow one of their recommendations. So agencies generally will do what GAO tells them to do. Now, there is the option, if a protester is unsuccessful, they can take their protest to the Court of Federal Claims and essentially appeal the protest decision, although it's not a true appeal, because the Court of Federal Claims will consider GAO's decision-making, but they essentially look at it as a brand new protest. But it is an option for disappointed or unsuccessful protesters. Next slide, please. Okay, next is the Court of Federal Claims. Again, you can pursue a pre-award or a post-award protest at the Court of Federal Claims. It's the only court where that is allowed. And you can file a protest either after a GAO protest or after an agency-level protest, or you can file it instead of a GAO protest or an agency-level protest. Now, the Court of Federal Claims is not bound by any GAO decisions, but they do give it deference. And there is a $400 filing fee to file at the Court of Federal Claims. Now, it's important to note that because this is a court, generally speaking, these protests are the most expensive of the three options. There are typically many more filings and calls with judges and meetings with DOJ and a lot of other things that increase the amount of time and money that's spent on the protest. And there is no automatic stay in a Court of Federal Claims protest. If a protester wants to stop the procurement pending a protest, either pre-award or post-award, they are required to actually file for an injunction, which again will add to the time and expense of pursuing the protest. Okay, so I guess we're seeing the end here. So that concludes my presentation on Bid Protest 101. Thanks everyone for listening in. I've included my contact info here in case anybody has any follow-up questions. I'd love to hear from you. Thanks a lot.
Great. Thanks, Brian. Thanks, everybody, for joining us. We're going to jump off of this one and jump on to our 12:30, which is starting in about 2 minutes, for the return on investment of bid protest. Next week, we are covering 7 steps to capitalizing on federal government Q4 contracts. That's the 12 o'clock session. And then at 12:30 is resubmitting a rejected GSA schedule. Today's presentation has been recorded. It'll be available on our website by the end of the week, or you can find it on our YouTube channel later today. Thanks, Brian. Thanks, everybody, for joining us.